my colleague from Florida, Mr. Rooney.
Thank you, Chairman Ross-Lehtinen, Ranking Member Berman, and members of the committee. Thank you for the privilege to appear before you today and for holding this hearing. As a former professor of constitutional law at West Point, I have tremendous respect for our founding fathers and the roles regarding military engagement they assigned to the executive and to the legislative branches. I am not here to debate the constitutionality of the War Powers Resolution and will leave that to the Supreme Court. However, before discussing the President's adherence to the war powers or lack thereof, I think it's important to discuss the general concept of how the United States goes to war. Article 1, Section 8 vests in Congress the power to declare war, raise and support the armies, and to make all laws necessary and proper for the execution of these powers, while Article 2, Section 2 establishes the President's role as Commander-in-Chief. The framers' intent is clearly for two branches to work flexibly and in tandem. Congress's true check on executive authority is its power of the purse and raising of armies. I think it's fair to say the United States would not have a military for the President to command without the structure and funding that Congress authorized to create it. Now let's fast forward to November 1972. The opposition to the war in Vietnam was at its height, and that year's election brought a Democratic majority to both chambers. The following year, Congress passed the War Powers Resolution, overriding President Nixon's veto. Operating under its constitutional authority, Congress essentially asserted, if you're going to go to war and send our troops into harm's way, you need us and the American people on board. Thus, if the President and Congress must agree on warfighting, then the United States will enter into fewer wars, and the conflicts we do enter will only occur after sufficient reason and deliberation. The War Powers Resolution requires the President to notify Congress within 48 hours of committing armed forces to military action and forbids armed forces from remaining for more than 60 days without an authorization of the use of military force or a declaration of war. When President Obama first announced his decision to join our NATO allies and intervene in Libya, he operated within war powers and notified Congress of that decision within 48 hours. However, on May 20, 2011, day 60 of the United States engagement in Libya, the President waited until late in the evening to send a letter to Congress. In a futile attempt to obtain our support for the efforts in Libya, the President again refused to make his case to Congress, requesting we simply endorse a carte blanche resolution supporting limited efforts such as this in Libya. Obama's intent to engage is clear. Outlined in an April memo out of the Department of Justice, the administration argued that the hostilities are of limited nature, scope, and duration, and thus do not rise to the level of war. Instead, the administration preferred to describe our engagement with a more redundant euphemism, kinetic military action. Neither the War Powers Resolution nor the Constitution provides any illusion that if an act of war is small or led by NATO, then it is not an act of war. This flies in the faces of Obama's own words, as Representative Amash previously stated, when he said in 2007, the President does not have the power under the Constitution to unilaterally authorize a military attack in a situation that does not involve stopping an actual or imminent threat to the nation. To date, it has been 65 days since the President has been acting unilaterally without Congress, 5 days longer than permitted by law. My bill, House Concurrent Resolution 32, expresses the sense of Congress that the President should adhere to the War Powers Resolution and obtain specific statutory authorization for use for the use of United States Armed Forces in Libya. My resolution does not speak to whether or not military action is or is not warranted. It may very well be, but rather that the President make the case to Congress to allow the Congress to debate it and thus determine at some point if we are on board. What we're asking for is simple, that the President respect our role in the spirit of the Constitution, the separation of powers, and the rule of law. Thank you for this opportunity to discuss my legislation, and I welcome questions the members may have.
Thank you.